presentation. Thanks for listening. So let's move on to the Q&A section. That's the end of our presentation.
Thank you. Very good. What your presentation is well prepared. So, so you think that your case is about mutual mistake, right?
Yes.
Okay. Thank you. Good. What is the difference between a unilateral mistake and a mutual mistake? Just a mistake of fact. If there's a mistake of fact, right? So material mistake of fact, and if it is a bilateral mistake, then what? And if it is a unilateral mistake, then what? Maybe you can tell me the legal consequences.
So the differences between bilateral mistake and unilateral mistake are like bilateral mistake occurs when both parties are misinformed as to the contract meaning and terms. On the other hand, a unilateral mistake means that just one party is misinformed as to the terms or meaning of the contract.
Okay. Hold on 1 second. There's an issue here. So, what is your group number?
We are group number 2.
You are group number 2. Why another classmate saying to me that group number 2 is another one?
Sorry. We are from group number 4. Sorry.
Number 4? Okay. Yes. Oh, okay. All right. Sorry, group number 2. So I didn't check that, and I thought that they already knew their group. Okay, group number 2. Yes, you will be next. Okay. Sorry, and please pay attention to your number. So you are number 4, right?
Yes.
Okay. Thank you for checking with me. Okay. So what is the legal consequence of a material mistake of fact made unilaterally or bilateral? You know what? Okay, bilateral mistake and unilateral mistake. What is the legal consequence if it is the material of fact? Can you guys hear me?
Yes, give me a second, please.
Sure.
Sorry, can you repeat your question, please?
Yes. So I'm asking if there is a mistake of fact, right? Is there any difference in terms of legal consequences if it is a bilateral mistake or if it is a unilateral mistake?
So, can I answer the question for her?
If you are in the team, are you in the team?
Yes.
Okay, yes, go ahead.
So, in terms of mutual mistake, the contract can be canceled by either party, and on the other hand, in terms of a unilateral mistake, the mistaken party cannot really form their contract, and So in other words, the contract is enforceable against the mistaken party.
Very good. Sang, right? Thanks, Sang. Is there any exception to that, to what you have just said? Is it gonna what you have say is correct? That is generally right, but can it be applied to all the cases? Is there any exception?
So in my belief, there is also an exception. Okay, so let me guess. So like in case that the other party to the contract knows that that a mistake was made, or should have known that a mistake was made.
Okay. All right. Thank you. Anyone in the group would like to add any further information? How about mistake of value then? If there's a mistake of value, like mutually, then what happened? Guys?
I'm sorry. So could you please repeat the question?
Sure. Mistake of value. What happened? What is the legal consequence if a mistake related to, the value or the quality of the object of the contract?
I think that only a mistake effect to may allow the contract to be avoided.
So in mistake of value, the contract should be
Enforceable.
Okay, it's enforceable.
Yes.
Okay, thank you. Good. All right, I think time's up as well. Right. So thank you. Thanks, group 4. Group 2, please. Group 2, please. Are you ready?
Yes. You allowed to share screen?
Yes. Who will we eat? So I will let you share the screen.
With Bảo Ngọc.
Ngọc, can you speak up so I can see you?
Yes, miss.
Yes. All right. Thank you. Hold on. Right. Good. Okay. All right. Let's get started, guys.
Hello everyone. My group members include Hoàng Yến, Thúy Vi, and Bảo Ngọc. The context of the case we present has been shown on the slide. L has hired P to purchase mineral lease in its county and with the intention of reselling those leases to other buyers. P asked M for assistance in obtaining the lease without notifying L.
M&P agent agreed to require M for his assistance in the purchase of oil, gas, and mineral lease. Another encounter and another mineral lease in Counter X. L did not sign the agreement. Finally, and so we because we did not follow the agreement. So my group presentation is based on IREC method. And first of all, regarding the legal issue. The legal issue here is whether the contract between M and P is valid and whether M will receive compensation. The next, my group will deal with relevant law to solve legal issue. In this case, the relevant here is the law dealing with the problem is related to contract law. And our team reviewed and found that P violated the fraudulent misrepresentation, which is when one party gives false information in order to entice them to perform a contract. Specifically, in this case, is silence at misrepresentation. So for application fact 2, it plans why P was accused of fraudulent misrepresentation. P made a false presentation of material facts for concealing both M and L about the fact that B did not inform L of the contract with M, while B is just a party hired by L. This means that B intended to deceive the innocent party as M. And besides, M relies on the misrepresentation that M would be compensated for his assistance. However, in reality, M was not paid for contractual effort and was injured. In this case, but P is accused of committing silence as misrepresentation because of the failure to notify L of the contract between M and B, as well as M ignorance of this, which constitute a failure to act in good faith. So finally, if we were the judge, the case would be ruled that the contract between P and M was invalid because B had violated fraudulent misrepresentation, and M has the right to appeal for compensation. Thank you for listening.
Okay, thank you. So you guys think that this is an issue of fraud?
Yes, miss.
All right, anyone else? Anyone else, either in the team or from the class, have a different idea? All right, so in this case, right, the plaintiff sought to obtain the payment for the performance under the written contract. to assist the defendant in acquiring mineral leases, right? So this is actually to illustrate what we study when we study the writing requirement, right, of a contract. Okay. And the answer would be that, you know, B was not liable for the agreement to compensate M. Okay, so regarding the agreement, under the US law, there is a statute stipulate that certain types of contract must be in writing. What is that statute called? Can you guys hear me?
Yes.
Okay.
Could you repeat your question?
Sure. So in the US law, right, under the US law, every state has a statute. They stipulates what types of contract must be in writing. What is the name of the statute? Not all contracts must be in writing, right, to be valid and enforceable. However, under the state law, some certain types of contract must be in writing. And how do we call that kind of document? What is the name of that kind of that statute?
Statute of frauds.
Okay, statute of frauds. Okay, good. So in statute of frauds, for example, if we orally agree to sell a piece of land, A orally agree to sell a piece of land to B, right? And later on, A decide not to do that. Generally, can be enforced the contract.
So A sell intend to sell the land and B also agree with that, but between A and B didn't have the contract, so it's not impossible.
Why not?
Because I think the land lease or sell lands must be in written
Okay, it must be
as
invited.
contract.
Okay. What? Where do we find that requirements? Where do we find that? Yes.
It is according to the statute of fraud.
According to the statute of fraud. All right. So the statement, if we say that the statute of fraud can be considered as a defense to the enforcement of an oral contract for the sale of land. Is it true or false? That statement?
Could you repeat your statement, please?
Sure. The statute of frauds is considered as a defense to the enforcement of an oral contract for the sale of land. Is that statement true or false?
I think not really, because
Yes or no? Don't sorry, not really. Is it true or false? Anyone from the team can help, not only one person. Yes or no? True or false? Just true or false?
false.
Okay, false. Okay, why false? Why are they false?
Because there is some sections, for example, in many states, have an exception to the writing contract requirement for lease. If that contract is shorter than a year, we don't have to make a written contract.
If a contract that okay, if the contracts that cannot by their terms be performed within a year from the date or after the date of formation.
Yes.
Okay, so you think that if it is less than a year, then it cannot, it doesn't have to be in writing, even though it is a sale of land.
I think so. It's up to each party when they agree.
Okay, but if they say that the contracts involve interest in land, must be in writing, so what? All right, okay, thank you. I have the that's that. I think that's enough. Okay, group 2, right? Thank you. Group group 3, please. Group 3.
Yes.
Do you need screen sharing?
Yes, I am.
Okay, so who will be the person who share the screen?
Me.
Win, right?
Yeah.
Okay. All right.
All right. So good afternoon, everyone, and welcome to our group presentation. We are group 3, and our group members are me, Mai Huỳnh Nghe, Lê Khánh Linh, Phạm Thái Châu Long, Lê Quang Minh, and Nguyễn Trịnh Thảo Nguyên. So this is the table of the contents. We just like other groups going to present our topic in the IRAC method. The first one is issues, and then we're going to have the rules applications, and the last one is conclusion. So the very first part of the presentation is the case. So we have two parties. The first one is the plaintiff ABC, and the second one is the defendant K. So ABC had a contract with K to construct a country residence for him. And a specification in the building contract required ABC that all wrapped iron pipe must be well galvanized lap weld pipe of the grade known as standard pipe of X manufacturer. However, ABC installed substantially similar pipe that was not of X manufacturer. And when K realized the difference, K ordered ABC to remove all of the plumbing and replace it with the X type. And in order to do so, the removing will require the finished wall to require the finish that encase the plumbing to be removed, which is a very expensive and difficult task. And ABC also explained that the plumbing was of the same quality, appearance, value, and cost as X pipe. On the other hand, K refused to pay $6,000 that K still owned for the work, and ABC sued for the compelled payment. So we have a question here is that if our team was the judge, what would our team decision? So the very first thing we want to introduce you is the issues of the case. We have a question that whether the act of replacing standard pipe of X manufacturer by similar pipe that was not of X manufacturer of ABC constitutes a breach of contract. So to answer this one, we want to introduce you to the principle we base on, which is the rules. We have the substantial performance and inferior performance. We assume that K, based on the inferior performance, to argue that ABC should have done what ABC agreed in the agreement, that is replacing with the X manufacturer pipe. However, ABC didn't do so and come to a conclusion that ABC has committed a material breach. On the other hand, we based on the substantial performance, which is a minor breach, to argue that ABC company has substantially finished is work agreed with K, but with small adjustment in the construction. So moving on to the next slide, we will have the application. So we have three arguments here. The first one is the good faith. So we could see that ABC has replaced the pipe in good faith because ABC has used the pipes that similar appearance, similar quality, cost, and value as to the X manufacturer pipe. If ABC was not at good faith, ABC would have used a low quality pipe. On the other hand, because the two types of pipes were very similar, very equivalent, so there's no big changes if we're going to use the other one. And the last one is the same benefits is quite similar to the second argument. We also want to add that because the cost and the effort to redo the already constructed pipe is unnecessary and difficult and costly, Therefore, we can come to a conclusion that the re-replacement is no need to be done. So based on the regulation and the application, we can come to a conclusion. We have the conclusion that the appellate court's decision we agree with the appellate court decision that ABC has substantially performed the contract, and ABC does not have to replace all the pipe, and K will have to pay a decent amount to ABC, not a whole $6,000, but an equivalent amount to the effort of the ABC company. So that's the end of our presentation. Thank you for listening.
All right, okay, thanks, group 3. Good job. So you are talking about substantial performance, right?
Yes.
So substantial performance is not perfect, right? So how is there any name for a performance that is perfect?
That's a complete performance.
Good, right? It's complete performance. So for it's okay, you can just stop sharing the screen. So what is there any difference between now you already say that, right? The material breach versus a minor breach. So what is the legal consequences between if the breach is minor then?
If the breach is minor, the non-breaching party recover damages equivalent to the minor breach.
Okay, anything else? How about the duty to perform? The non-breaching party duty to perform. What happened? Will they be excused?
I don't quite understand your question.
Sure. So if a breach is minor, right? The non-breaching party's duty to perform. What happened to that duty? Is that duty going to be entirely excused? The duty to perform the contract.
I understand.
Okay.
So if the minor is breach,
if the breach is minor.
Yes. If the
no
breach
worries.
is minor,
okay,
then the breaching parties.
Non-breaching party.
The non-breaching party's duty is not wholly excused. The breaching party still have to perform his or her obligations, his or her duties.
Okay, good. Is there any chance to delay that duty?
To delay the duty, that because the breaching party has made a minor breach, so the non-breaching party may convince the breaching party to elevate his or her performance to complete the whole performance.
His or her, you mean the non-breaching one or the breaching one?
The breaching one.
Okay, no. What I'm asking about the duty. Is there any way that can the duty to perform, can the non-breaching party's duty to perform be delayed, or it have to, even though there is a minor breach, they still have to do that? So if
Oh.
just imagine that is a case with a house, right? So there's a minor breach because you think that it's substantial performance. So do the owner have to pay the money immediately? Does the owner have to pay the money immediately, or will there be a time lapse? Or the owner is the non-breaching party, right? So does he or she have to pay immediately the money to pay the contractor, the builder?
I think that the non-breaching party doesn't have to pay immediately for the breaching party.
Why? They can wait until when?
They can wait until the breaching party finish fixing the bridge, or however find a replacement, or perform in other way to complete the whole performance of the breaching party, and then the non-breaching party will then pay for the breaching party.
Good, very good. Right. So in other words, you can say that it can be delayed until the breach has been remedied, or you can say that until the breach has been cured, right? And then
yes,
the non-breaching party can presume they perform their duty to perform. Okay, then the non-breaching party must presume their performance. Okay, good. It's just you say it correctly. It's just the technical words, right? Just,
yes, understand.
Yep. All right. Thank you. Very good. Thanks, group 3. All right. Is there any other volunteer? So we have 6, 7, 8. We have 6, 7, 8. Nope. Okay, so let me do the word thing here. Okay. Okay, group 8. Please.
Can I share screen?
Sure. Free, right?
Yes.
Hello everyone, welcome to the group A. My group includes 3 members, which are Hà Trang, Thảo Vi, and me, Kim Phụng. So today we're going to talk about 3 parts. Part 1 is case, an overview of the case. Part 2 is analyze the case follow with the IRAC method, and the last part is Q&A. So let's start with the first part, the case. So the case about A, who is one of the contestants of a card tournament sponsored by Card League. When entering into the final event, all contestants sign an agreement that CL would pay the tournament winners entry fee and travel expenses to the World Series of cards. And from now on, we call it Q-Shot. The agreement also stated that if the winner did not attend the Q-Shot, he or she would give up the Q-Shot seat and return the expense money to CL. After all, A won and received $6,500 for travel-related expense, but did not attend the Q-Shot. After that, A filed a lawsuit for $11,000 against CL, arguing that it has adverse that the winner could choose to receive the cash values of the prize instead of going to the Q-Shot game. So A also claimed that he has accepted CL offer by participating in the tournament. So the question here is, if my group is judged, would be our decision. So here's our discuss. So in this case, the parties include plaintiff is A and defendant is CL. About the case, the legal issue in here is whether A received his cash value of the prize, which is $17,000 instead of going to the Q-Shot. By the rules. The rule using here, the UCC, the Uniform Commercial Code. So here is our analysis. Well, we assume we have already known that to forming a contract, we must have four elements, which are agreement, consideration, contractual capacity, and lawful object. We assume that both parties will have a contractual capacity and lawful object. So we only consider to a valid contract must have. So in here, we see that a valid contract must have an offer, mutual agreement, and the offer is accepted. Based on the case, we see that the offers is made by CL, and mutual agreements also have, and mentioned to the agreement accepted. This can be seen by A signed the agreement. That means the offer also accepted. Therefore, we can see that even though A acknowledged the advertisement stating the information of receiving $17,500 or going to the Q-Shot, A still entered into an agreement with CL, which state that A can only go into the Q-Shot, or A must return the seat and the expend money to the CL. Therefore, the advertisement is invalid, and the agreement between A and CL is valid, which bound both parties into this. Therefore, both parties must follow the terms that have been stated in the agreement. And after that, we say that the contract was not formed. The previous slide, please. Thank you. Therefore, the contract was not formed when A began participating in the contest, and then we realize that the court of action that A accepts $6,500 for travel-related expense from sponsor, but not attended to the Q-Shot, is one of the action of unjust enrichment. And therefore, we come to the conclusion as follows. The court will rule in favor of CL, and A would not receive his cash value of the prize, which is $500,000, instead of going to the QSOC, and say that the advertisement would be invalid. And the final rules is A must return the amount of money to CL. And that's also the end of our presentation. Thank you everyone for listening.
Okay, thank you. All right, so we are talking about contest, right? In this case, right? It's a type of competition. So this case can be used as an example of what concept that we have discussed. That we have studied.
Well, our group think that it might be a part of executory contract because both parties have not fully performed.
Executory, okay. Anything else?
And the contract, which is the agreement between A and CL, is a valid contract, whereas the advertisement that A mentioned is a void. It's a void contract.
Is a void contract, okay. Anything else?
And we also think that is also the express contract because in the agreement, it states expressly that the winner have to go to the QSOC and receive the travel expense, or otherwise, or else the winner must return the money to DCL.
Okay. All right, so this one is actually related to an offer to form unilateral contracts. Okay. So so if a person complies with the rule of the contest, is a unilateral contract formed based on your understanding?
Sorry, Miss. My connection wasn't stable. Can you repeat the question again?
Yeah, sure. If a person complies with the rules of the contest, is a unilateral contract formed?
So I'm not really sure that I understand your question well. So may I paraphrase that? So you mean that somebody is not the winner enter into the contract? So would that contract is unilateral contract, right?
If a person complies with the rule of a contest, right? He is the contest, right? The tournament, right?
Yes.
Yeah. So if the person complies with the rules of the contract, is an unilateral contract formed?
I
Any other people in the team can help?
well, I think it's also a unilateral contract because that person
The answer is yes or no. I'm asking you, the team.
I think the answer is yes.
Why?
No, sorry. My group says no.
Why not?
But I do. Contract.
Okay, can you go back one slide, please?
Yes.
No. Go back. Go to the conclusion. Yes, stop there. No, back. Yes. Okay, thank you. All right, next one. Oh, time's up too. Okay, thanks group 8. We have 6 and 7. Which one would you like to go first? Okay, 6, please. Group 6, please.
Yes, miss.
Yes.
Can you hear me, miss?
Yes, I can hear you. But you have the background noise.
Yes, could you allow me to share my screen?
Can you? It's the background noise is pretty loud, so.
I'm sorry, because my surrounding is a little bit noisy. Let me double check.
Yeah.
Okay, so now can you hear me?
No, it's worse. Is any other member can present?
Now is this better now?
Just a little bit, but it's okay then. Please go ahead.
Sorry for this.
Yeah, no worries.
Miss, can you allow my team member Ngọc Thảo to share the screen? Okay, so hello everyone. So my name is Ngọc Yến. So on behalf of Group 6, and now I would like to have a presentation on case number 3 that Ms. Lin have given to our group. So first, I'm sorry because my surroundings is a little noisy. So if you can hear me well, so please let me know so I can make it better. Okay, so for case number 3, so let's begin now. So now on the screen is the summaries of the case. Case number 3. So first one, the plaintiff here is B, which is the Technologies Corporation, which creates software and provides technical services for a Japanese language website. And this website is owned by the defendant B, Amscom. So here's under referred to by A. So later at the end of 1999, B and I entered into a stock purchase agreement. And later, B sued A for various claims and failed to pay for additional services performed by B. Then A and B want to settle out of court. So here's an important fact of the case that we would like to highlight because it's important. Key fact to determine this case. So during the trial, mid-trial, A and B want to settle out of court via a series of email exchanges by both parties, which constitute a settlement. Yeah, a series of email exchange to settle out of court between the plaintiff and the defendant. So later, A reneged, which means A doesn't want to perform to fulfill the obligation under the settlement between A and B, as aforementioned. So then B served a motion to enforce the proposed settlement. So here's let's come to the main part of our presentation, the issues of the case. So here, the issues of the case is whether the settlement between A and B at the mid-trial has constituted a legally binding contract, which means that this is have the enforceable under the law. Is the settlement have the enforceability and bind the two parties to fulfill their obligation under this settlement. So this is the issue of the case. Let's move to the next part, which is the rationale. So here I will use the 4 elements for a contract to be enforceable, to be legally binding. So the 4 main elements. So here we would have the agreement, the consideration, the contractual capacities, and the last one is the lawful object. So here you can see the natures of the element, of the 4 elements. And to discovered deeply about the problem, let's move to the application. So for the first element, agreement, so here in this case, we can see that both parties have mutual consent because they agree to exchange the emails and reach an agreement. So here we have a series of emails that mean each parties have tried to send and reply continually in a period of time, which means they just have the offerer and the offer agrees and they accept to exchange emails to reply to negotiate via emails. For the second element, we have consideration. So in terms of consideration, so here, the act of exchanging and bargaining, or you can note and negotiating via a series of emails is technically itself a form of consideration. The third element that we have is the contractual capacity. So both parties are a corporation company, which means they are legal entities which have enough capacity to create and enter into different types of contracts under the US law because they are legal entities. And for the final, the last element, we have lawful object or legality. So the object of this contract is legally binding. Here, the object of this contract is the settlement, and the settlement itself is not again the law regulation, which means it complies with the regulation of the law. So come to the conclusion. So if a group were the church, we would agree to the solution in which the email exchanges constitute a complete and unambiguous statement, a complete and unambiguous statement of the both parties about their desires to be bound by the settlement term. So as such, the aid, which means the defendant in this case, the company needs to fulfill its obligation under the settlement. Or in other words, we can say that the mid-trial settlement here in this case can be enforceable, which means the plaintiff have their rights and have the ground to initiate a court.
It's okay. Thank you.
Yes.
Your presentation is much longer than the time allowed. All right, thanks. So what is the issue here? What is the issue that they are discussing in this
Okay, so
example?
according to a group, the issue here is whether a series of emails exchanged between the two companies during the trial, it means the mid-trial settlement agreement, can be enforceable under the law, can be considered as a binding contract and have the enforceability.
Okay, all right. So this one is actually specifically is about preliminary agreements. Okay, so it's like whether all the preliminary agreements can constitute as a binding contract. Okay, thank you. Let's see. So what are the requirements for an offer to be valid?
Sorry, Miss, can you repeat the question?
Requirements for an offer to be valid, what are they?
So I think the requirements for an offer to be valid is it is accepted by the offeree. It is accepted by the offeree.
Okay, thank you. Anyone else? Anyone from the group? Requirements for a contract to be, sorry, the requirement for an offer to be valid. What are they?
Miss, there are three requirements for effective offer. First is offerer must objective intend to be bound by the offer, and the second is the terms of the offer must be definite or reasonably certain. Reasonably certain, and the final is the offer must be communicated to the offeree.
Sure, thank you. So because this one is I'm asking that because this is relating to preliminary agreements, right? So whether preliminary agreements will constitute a binding contract, right? So can you please name some situations? You say that there must be an intention, right? So can you name some situations when intent may be lacking? Name and then give some example to illustrate that. Is this related to the one we are discussing? Situations when intent may be lacking.
Sorry, Miss. Can you repeat the question?
Can you please list some scenarios when intent may be lacking? Sorry. Can you answer that? It's okay, time's up. All right, so last group then. Group 6, please. What group is that? The last one is, sorry.
So we are group 6, Miss. We are group 6.
Yes, group 7, I'm sorry. Group 7, please.
Miss, can you hear me?
Yep.
Miss, you can let me share the screen.
Okay.
So now I'm going to start our presentation. We are group 7 and our group includes 4 members, Bảo Ly, Thảo Long, Thu Thủy, and me, Bảo Thi. And so today we talk about this case number 2. Yeah. And so I'm gonna continue with the IRAC. And the question that arises at this point is whether the company SYS could modify or terminate the terms of its offer to pay the one-time bonus by imposing a cap on it. And we apply the US business law. Here we have the company SYS promised to pay bonus in return for an at-will employee's continued employment is an offer for a unilateral contract. And generally, an offeror can withdraw an offer at any time before the offeree accepts it. The offerees of a unilateral contract offer to make the offer irrevocable must merely begin performance. And so in this case, because of each of the managers here had at least begun performing under the offer, we conclude that SYS could not modify the offer terms as a unilateral contract offer after the offeree begins performance is to protect the offeree's injustifiable reliance on the offerer's promise. And in addition, the company must foresee that the event of economic downturn when they making the bonus offer. So in conclusion, if we are judged, we would conclude that the company SYS is liable to pay the general managers the bonuses that this company initially promised. So this is the end of our presentation. Thank you for your listening.
Oh, that was very fast. Can you go back to the conclusion, please?
Conclusion. Here.
Okay, thank you. You are group you're group 7, right?
Yes.
What question again?
The question.
Okay, I see that. Okay.
Yeah, here.
So what? Okay. Yes, yes. Can you please go to the conclusion?
Okay.
Okay, so what is if this case is used as an example to illustrate one concept that we have studied, which one that you think would be suitable?
Like a breach of unilateral contract.
Unilateral contract?
Yes.
Okay, a breach of a unilateral contract is what you say?
Yes.
A breach of a unilateral contract. Okay. Breach. Are you sure that it could be the suitable term for that?
I just think I mean
what does it mean when we say a breach?
But because this company promised to pay bonus for the managers, and this make up a unilateral contract, and then they want to change the terms like they want to create a cap of the amount. So that is not the it's not the same as the initial terms. So I think it's a breach of contract.
Oh, okay. So how about any other people in the group?
We have discussed before, so
So, but go,
this
yes, go ahead.
conclusion is we are all agree about this conclusion.
Oh, okay. You all agree with this conclusion? Thank you. All right. Actually, the more appropriate word would be, how can I say, revocable, okay, or revocation. It could be more suitable than breach. Okay.
Yeah.
All right, but no worries. So when an offer can be revoked?
I mean the offer can be revoked when the offeree has not accepted yet.
Okay, when the offer had not been accepted, that's what you say?
Yes.
Is it going to be applied most of the time, all of the time?
I think so. I think it's
All of the time that then an agreement can be revoked until it is accepted. That's what you say.
I think so.
Okay. That's what you say. So how can we communicate our revocation? How can we communicate our revocation?
I have a little bit hard to understand your question. Can you explain it?
Sure. How can we communicate our revocation?
Communicate
How can we communicate our vocation?
Sorry, I can't speak. I don't know.
You don't understand my question?
Yeah.
Communication. How can we communicate our vocation?
Like communication, the offer must be communicated to the offerees.
No, we
By-
communicate our revocation. How do we communicate our vocation? How do if we want to revoke an offer, right? How can we communicate that to the other party?
by express a statement or by act inconsistent with offer.
Okay, can you please clarify a little bit? What do if you want to do it as an express statement? How do you do? How would you do? Can you give example, please?
Like I would say I revoke something or.
Okay, all right, it's okay. All right, thank you. Yeah, okay, thank you guys. Okay, we're finished. So unless you have any question, let's stop for now. Good luck with the preparation. I think that as Nga said, your final is going to be the beginning of April, right? So please have a look more at Vietnamese law. That is what I'm concerned, and compare and contrast with the US law. Following the guideline on the slide, I will, if I can, right, I will try to ask as much as the US law as possible, but definitely there will be the Vietnamese element in the exam. Okay, so do you have any questions so far?
We don't have, well, currently I don't have questions, but I just want to say that for the last semester, as we we were doing a test for taught law teaching by Miss Bình. So we encounter several difficulties that we somehow cannot manage to answer all the questions in both aspects of US law and Vietnamese law. Since the question is a little bit overwhelming, like too many questions. So would it possible if we can like have fewer questions in the test?
I cannot decide that, right? Yes, so I have to follow the guideline that requested by the school university or by the division. But as I say, since this is the last semester, I don't want to give you guys a hard time. And I think it's no doubt. You're not the kids anymore that I have to force you to study or anything. I will not give you the hard time, but I have to follow the structure instructed by the division. Yep, but I will try to, that's as I say. So first of all, I already eliminate the commercial law in the exam. So you just need to read the civil law. And second of all, I have to put, if I am the one who give out a question, I don't know who, but if I'm the one who give out a question, then I have to put the Vietnamese aspect in there, but I will try to minimize it. Okay, that's all I can do. And I'm not, again, as you can see through the midterm exam, as long as you read the book or as long as you were in class, then you will not have any problem passing the exam. Of course, if you are aiming for 10 in a final exam, that is a little bit challenging. But if you just need to, I'm not asking you anything outside of the lecture or the book, right? So as long as you read, you just need to read to know where it is so you can look it up, right? You don't have to learn all of them by heart. That is one of the advantages. But I will try to minimize the question to make it feasible. But regarding the number of questions, and I cannot decide that. Okay, but I will try to make it as simpler as possible. Not like, you know, too simple, right? Because then that would be, then the question will be against me, like why the exam is a joke, right? But I will not give, I'm not going to challenge you, I'm not going to give you a hard time. Everything I ask will be in the book and in the lecture. That's all I can promise. Okay.
Thank you very much.
Yes, no worries. All right, any other questions? Okay, otherwise have a nice weekend, and hopefully I'll see you guys again soon. I mean, not in my class, right? Elsewhere. I don't mean that you're gonna fail. What? Just say. Okay, so just read. Spend a little time every day to read it a little bit, and then you will be fine.
So would it possible for us to receive the midterm test or the final exam?
You want the midterm test?
I'm sorry, my bad. Would it possible for us to receive the midterm test score?
The results?
Yeah.
Okay. Sure. Let me see. And then so maybe you can have some feedback or something. That's what you say?
Yes.
Yes. Okay. Sure. I'll try. But then I don't, because so far I have not got anything from my faculty yet, because in order to enter the grades or anything, I need to have the paper, you know, from the faculty. So I need to wait for them. So if I receive that before the final exam, then I will definitely share with you, yeah, so you can share with the class. Okay.
Okay. Thank you very much.
Yeah, no worries. All right. Have a nice weekend then.